to the Supreme Court, where the justices ruled that Idaho hospitals must perform abortions in emergencies. This after the ruling was briefly posted online yesterday. In the 6-3 ruling, the justices said the exceptions to Idaho's near total ban are too narrow. Abortions are allowed only to save the life of the mother. The High Court says the Emergency Medical Treatment and Active Labor Act, also known as EMTALA, allows abortions when a woman is faced with other risks, such as a loss of fertility. The case now returns to the lower Ninth Circuit Court. And for more, let's go to Carrie Severino, president of the Judicial Crisis Network and a former law clerk for Supreme Court Justice Clarence Thomas. Carrie, great to see you. First, your thoughts on the justice's ruling, which, as we said, was leaked yesterday but officially released today.
Yeah, well, first, it's important to realize that the justices didn't actually rule on the merits of this case yet. They have not officially weighed in on whether EMTALA, the Emergency Medical Act, overrides Idaho law. They simply said, we need to let this work all the way through the courts. And normally that would be what would happen. They kind of went out of their way to take this case. And now 5 justices said, on second thought, let's let it go back to the normal process. That's frustrating for everyone who put in a lot of time and effort to brief this case and to get it up there. But the case has been a bit of a moving target, both because the Idaho law has changed somewhat in the pendency of the litigation, and because the United States, in its arguments to the Supreme Court, made a lot of serious concessions. And that was ultimately what Justice Barrett said was dictated her decision that was joined by the Chief Justice and Justice Kavanaugh to send it back, let them take this case on up again, and see if, after the government agreed that, for example, conscience exceptions do have to be made to this law. You can't force doctors to do forced abortions, and that and that perhaps, just for a woman's mental health, they can't force the hospital to have an abortion. Maybe there'll be nothing left of this case after that's done. Maybe it will have to work its way back to the Supreme Court.
Yeah, and jumping off of that a little bit, I mean, the ruling seems to provide really little legal clarity on emergency abortions. That said, do you think either side can really claim a victory on this decision?
Well, if there's any victory, it's for the federal government, unfortunately, in the fact that the stay was lifted. I think, it's a closer case whether the court should have taken it in this intermediate phase to begin with, or whether they should have returned it to the Ninth Circuit, on second thought, as they did. But I was very disappointed that the court didn't at least keep the stay in place, because before they at least had stayed the decision. They said for the interim, there won't be any abortions provided in Idaho that don't meet the life of the mother exceptions that are present already in Idaho law. Now, though that opens the door, I think we'll have to see what happens with that, how many abortions are provided in the meantime. And unfortunately, I think it also opens the door to potential gaming of the system by hospitals or doctors who want to create a record that makes it seem that those numbers of abortions are maybe higher than they actually are. Because it's actually a very narrow range that you can imagine of situations where a woman would experience long-term real health consequences, but also not be in a life-threatening situation.
Yeah, and Carrie, I mean, this is really the second case in about 2 weeks, I think, where there was cases related to abortion. Do you think, let's talk a little bit more about that, the mifepristone case in this case, and do you think both of those will be headed back to the Supreme Court?
Well, this one, I think, very likely will. The mifepristone case, unfortunately, probably won't, because the court decided it on standing grounds. What they said is the people bringing this case, the doctors, the emergency room doctors in that case, aren't the right people to challenge this regulation. And at this point, it's hard to know whether the time frame has already elapsed to be able to find someone who could be the right party to challenge those mifepristone regulations. You can imagine that a woman who, for example, had a serious health consequence or even had died in the family could sue on their behalf because of those lowered standards that unfortunately are now in place, opening the door to a lot of women receiving the drug in a way that's significantly less safe. So it's possible to imagine that coming back, but it would have to be a whole new case from scratch with different plaintiffs, and I'm not sure there's time following the regulation to bring that case.
All right, almost out of time here, but quickly, any final thoughts?
Yeah, both of these are kind of discouraging for the pro-life movement, I think. But remember, they were decided on procedural grounds, so they're not sending forth precedent that I think is going to be binding in future cases. They really were procedural things where this isn't the right case at the right time. Hopefully the court can clarify these questions going forward.
All right, Carrie, thank you so much for your insights. We appreciate it.
Thanks.